Kirsten. Good. Good morning, everyone. I'd like to call to order the Judiciary Committee meeting for Wednesday, February 22nd, 2023. Mr. Co-Chair, any remarks? If not, let's jump right into our agenda. Item number 3 on our agenda is a presentation by the Attorney General's Office and the Department of Children and Families regarding a stipulated agreement yes, and certain resolutions that are on our agenda today relating to a proposed settlement in the matter of Dallas Church versus the state of Connecticut. Whenever you're ready. And if you could make sure that, and just for the record, the Deputy Attorney General is joining us via Zoom, I believe. Yes. And she will introduce herself and her team. And we just ask when folks speak from the AG's office or DCF, do you identify yourself for the record at that time?
Thank you. Yes. Good morning, Senator Winfield, Representative Sastrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. I'm Eileen Mesko. I'm the Deputy Attorney General, and I appreciate the opportunity to provide this presentation. I apologize I couldn't be there in person. I do have several colleagues, I think, that are there. Cara Passero, our Chief of Staff, Lindsley Barbado, our Section Chief, and Carolyn, and one other attorney we have with us as well. And pursuant to Connecticut General Statutes 3-125, we're here to seek approval of a settlement in the Barrios Administrator of the State of Dallas Church versus State of Connecticut case. This case concerns a young child, now 8 years old, who was removed from his parents' care when he was 14 months old in June of 2015 due to neglect conditions in the household. DCF placed the child with Crystal McGee, his biological mother's cousin, and while he was in her care, she failed to complete DCF foster parent licensing requirements, to follow through with various medical and birth to 3 appointments. She contacted local police about his inconsolable crying. She complained to service providers about being overwhelmed and refused a substance abuse evaluation after DCF received a report that she tested positive for drugs in July of 2015. So despite all of these red flags and warning signs, DCF did not remove the child until November of 2015. A day after the child was removed and placed with another relative, that relative brought the child to the emergency room based on his condition and his appearance. And they immediately transferred him to the Connecticut Children's Medical Center, where they found the following conditions. He had multiple healed scars, visible ribs, untreated broken bones in both his arms, including his left arm that he was unable to use, multiple healed wounds to his feet, retinal hemorrhage, and he was unable to sort of talk or walk or feed himself based on malnutrition, and he had a traumatic brain injury as well. As a result, Crystal McGee was arrested and charged with risk of injury and intentional cruelty to a child. After carefully reviewing the records, conducting numerous depositions, and consulting with expert witnesses, our office determined that DCF, based on its own policies, should not have placed Dallas with McGee because of the family's child protection and criminal history. The DCF staff failed to seek information to establish the risks attendant to their history had been addressed, and did not seek the proper waiver from the commissioner to place the child in a home with a prior criminal and child protection history. So we determined with DCF's agreement that the best course was for the state to admit liability, something we rarely do, and for DCF's negligence in the placement, supervision, and care it provided to the child, and to focus on the damages to the child and the cost of his present and future care. The parties engaged several experts to assess his condition and potential future damages. And there was there was further discovery and expert witness depositions regarding the damages. Two of the plaintiff's experts, a pediatrician and a psychologist, opined that because of the severe abuse in Dallas's in the foster care, the child had severely limited functioning and significant emotional, behavioral, and psychological injuries throughout his life. The plaintiff's expert life care planner calculated the earning capacity at a little over $10,000 a year, with an estimated cost of $171,000 per year for full-time residential care. With added medical expenses, the total economic loss that they calculated was a little over $10 million. The expert economist by the plaintiff determined economic damages at almost 12 million, 11,600,000 and change. Non-economic damages for pain and suffering were not included in either one of these figures and would have been left up to a court to decide. The state also secured experts. We had an expert neuropsychologist who performed an independent medical evaluation of the child, and the expert confirmed that he did, in fact, sustain a traumatic brain injury, and that 5 months in the abuse in the home contributed to the severity of his overall deficits. They also concluded that the deficits in his areas are greater than they would have been had he had never experienced that abuse. But they both thought that with some continued care and rehabilitation that he could have more promising functioning than the plaintiff's expert. And there was no basis to conclude that he wouldn't be able to work, but that he would be limited. The state's retained expert vocational planner and rehabilitation specialist agreed that he would need lifelong care, but also opined that with proper treatment, he would be able to work in a low or semi-skilled job. But nevertheless indicated that the child would need lifetime supports to maintain consistent employment. As a result of these conflicting expert opinions, the parties reached a compromise settlement amount of $12 million, which significantly discounts the claimed economic damages and compensates the child for the pain and suffering he experienced in the home and the consequent emotional damages stemming from that abuse. And with that, I'll conclude. Happy myself or my colleagues to answer any questions you might have.
Questions to the committee? Senator Kissel.
Thank you very much, Chairman Staffstrom. Good morning, everyone. Well, this is a heart-wrenching case. On the one hand, we as a state have to step up and take responsibility for what one of our state agencies did not do, and that is to perform their job without clear negligence. On the other hand, as a member of this committee, one of my jobs is to make sure that taxpayer dollars are used wisely. So it's an interesting tension, because on the one hand, I want to make sure that this young man receives appropriate compensation for the problems that the state was responsible for. But at the other hand, I don't want us to have too much largesse, because taxpayer dollars are finite and hard won by the taxpayers of Connecticut. One of the things that has bothered me in this matter is that the state fairly early on acquiesced regarding issues of liability. And back once upon a time, I was involved in private practice where we had a very serious personal injury matter. It did involve the use of expert testimony. It settled. But again, it was an assessment as to future medical needs of the individual. The individual is a young man, was paralyzed. There was medical testimony that individual needed, would have urinary tract infections intermittently throughout his life. And so substantially similar. So one of the issues that came to mind when I had an initial review of this matter was the attorney's fees. And it's a delicate issue because I don't want to cast any disparagement on the law firm or the good job that they did on behalf of their client. But at the same time, it's my understanding that it's in the millions of dollars. And I'm just wondering, is there any limitation on what the state can do in negotiating a settlement such as this regarding attorney's fees? And again, I am not criticizing the law firm, but if we're talking about where liability is admitted early on, and it's essentially an argument between experts on damages, millions of dollars in attorney's fees seems a bit exorbitant. That's just me. And again, there's nothing illegal or inappropriate about what the firm has charged between it and its private client. But again, from when I go back to my constituents, they're going to say, what the heck is the state doing? And did they really negotiate as hard as they can when it's our dollars? And so that's my first question. Anybody, you got a zillion people here.
Could you turn your microphone on and identify yourself for the record, please?
For the record, Carolyn Signorelli, I'm an assistant attorney general and I was handling this matter. I just don't know if you want the deputy attorney general to respond to that.
I defer to.
I think we'll defer to the AG's office. Whoever is best handled to answer the question is fine with us.
Well, I'll wait to see if.
Yeah, so thank you, Carolyn. I'll just address it initially, which is, I understand the concern and I appreciate, the discussion here. I think the problem for us is in terms of the attorney fees, we don't have any ability to, I suppose if any lawyer wanted to reduce their fees, that's certainly within their discretion, but the statute allows for the fees as you've indicated. And so there really isn't an ability for us to negotiate that out separately. And it's not typically done because we look at what the actual damages are. And I just want to reiterate also that we do not typically admit liability in these types of cases. It's very rare. My experience has been, we have admitted liability in small property damage claims that come through based on the facts, but this was one based on what we saw initially. So the focus certainly was on the damages, and that still took a lot of time and effort to determine and to come to some resolution. But, I don't think we have any ability to do that based on what the statute allows for attorney's fees in these cases.
Yeah, and that begs the question. I don't think there's anything we can do in this particular matter, but since this matter's before us right now, I'm saying if there's anything we as a legislature can do to change the underlying statutes, so that in situations such as this, you would have more latitude. And trust me, if I work for a plaintiff's law firm and I'm on the other side of the table and we're talking millions of dollars and there's a potential settlement, if the statutes then going forward say that the Attorney General's office has an ability to make attorney's fees part of the negotiations, and that may get us to a resolution. Hey, 4 million versus 3 million. I mean, it's substantial amounts of money, but we're looking at justice and taxpayer dollars. So let us know going forward if there's anything we should change or contemplate changing in our statutory structure that would afford you more latitude in cases like this. Back to what you had stated, that it's the rare case where you admit liability at the outset, and usually it's a minor property matter. What specific circumstances in this case caused you to just accede to the issue regarding liability so early on? And my good friend and colleague, Representative Fishbein, showed me the litigation history, and there's a lot of motions, so it's not like there weren't a lot of matters done through litigation here. But again, it's like a hearing in damages, and I know there's work that goes into this, but it's a finite universe once you admit liability, and it's really mustering different experts and pitting the experts against one another, and essentially sitting down with either a judge or an arbiter and trying to hammer out a compromise, and that's it. I wouldn't even say this rises to the level of complex litigation. And yet we're talking millions and millions of dollars. And I don't want to seem parsimonious. I want us to do right by this young man and the people and the caregivers around him. And we did wrong as a state through our agency, the Department of Children and Families. But I'm just wondering why this case, if you can explain.
Sure. Let me start, and then I'm going to ask Carolyn to jump in because she did work on this case directly. But it's my understanding that when we first had this case, like any other case, we started with discovery and we did depositions, and pursuant to those depositions of some of the, I believe, DCF workers and others involved, and a review of the policies and the failure to follow their own policies in some of these cases. I believe also the Office of Health Child Care report came out as well, that it was determined early on that liability was clear. So I'll let Carolyn jump in if she wants to give more specifics on what happened at the outset of the initial part of this case when it went to Superior Court.
Certainly. For the record, Carolyn Signorelli, Assistant Attorney General. Just to sort of clarify a little bit about what's meant by admitting liability early on. When this claim has been around since 2017 at the Claims Commission. And when it was finally brought to Superior Court, that was in 2019, and the state did not admit liability immediately. There was a significant amount of discovery and depositions and motions practice that did go on prior to the state determining to admit liability, which wasn't until, I believe, August of 2021. So there was a significant period of time where liability was contested and a lot of work was done on the case before we, reached the conclusion that we should admit liability based upon the evidence that was developed during that period of discovery and all those depositions. And subsequent to admitting liability, the work around the issue of damages was somewhat complex in that it required several different types of medical and psychological experts to opine regarding this child's functioning, capacity, and future issues. Child abuse pediatricians, developmental pediatricians, psychologists, neuropsychologists, vocational planners, and life care planners. So subsequent to the admission of liability, there was a lot of work and continued discovery that went into determining what the damages would likely be or could be and what our exposure was. And, we determined that, we were facing the likelihood of a potential $20 million award if we went to trial based upon the state of the evidence. And that's how we got to the figure that we got to, even though liability was eventually admitted.
And okay, so this is an egregious case where after some discovery, you determined that liability was clear and not worth fighting over. Okay, what did we learn as far as an agency, maybe, as far as best practices by the Department of Children and Families, so that we're not in this situation again? And if it sounds like I'm frustrated, I am, because I don't view this committee and this process as a rubber stamp, and I don't know what we can really do. I don't think that we're going to end up in a position where we can reject this. But it's a huge amount of money when I go back to my district. I've got tons of small children in different school systems in my district. We can't afford to give each one of them $12 million. So this one individual is getting a huge amount of taxpayer dollars, and justifiably so. And maybe it's on the low side, given the prospects for the rest of his life. But again, I'm trying to rationalize how we do go about this process. And unfortunately, we've gotten to this state, and granted, it's an old case as far as years go, but here we are. And so what lessons learned did DCF put into place? I know that you shared this with me earlier, but I know some people quit their jobs. I'm not looking for retribution. But as far as avoiding this so that we're never in this situation in the future, I think that would be something my constituents would get some reassurance from. So if somebody could explain what the good takeaways from this are, aside from the litigation and the dollars.
Senator Kissel, I completely appreciate your remarks and your concerns. And I think that perhaps my client, who is represented here by Mr. Michael Williams, might be better suited to answer that question specifically.
Good morning, Senator Kissel and Senator Winfield and other members of the committee. I'm Michael Williams, Deputy Commissioner of Operations for the Department of Children and Families. Let me first begin by addressing your question and saying on behalf of the 3,000 and something employees of the Department of Children and Families, we're totally embarrassed by the practice that occurred on this case. This does not in any way, shape, or form represent the standard of practice that we had adhered to then and adhere to now. The policies, the procedures, and the standards of practice that we've always operated under was one that required every I to be dotted, every T to be crossed at every time, because you can do it 99 times. When you miss it the one time, it's the one time something can occur. And so our practice has been fidelity to our policies and our procedures that are in place for this very reason. The fact that individuals handling this case did not comply with the policy that was already in place and chose to cut corners, created a scenario that unfortunately this little boy ended up being maltreated. What we've done since then is strengthened those policies, strengthened our practice, assured every employee that there is no room for cutting corners, particularly when it comes to safety of children. The catalyst for what occurred here was the belief that the relative who came forward as a placement for this little boy was okay without going through the due diligence that we put every person through, which is an emergency home assessment, physically going to the home, observing the home, seeing all the aspects of the home that the child will live in, and looking at the individual who will be caring for the child, having a full assessment of all of that. If that alone would have occurred on that unfortunate Friday evening, this placement would not have happened. And so every emergency home assessment is reiterated by policy and by practice, must be done before a child is placed within the home of a relative or any caregiver. Relative care, kinship care is one that happens, immediately when a child is being contemplated for removal due to not being safe in their homes. And so they don't have the luxury of going through, a 4 to 6 month training process as core foster parents would, with background checks and trainings and all of that before a placement is made. Unfortunately, relatives get a knock on the door indicating that your relative child is in need of a caretaker. And then we have to assure that all of those aspects work out and get approved before that child is placed there. And so we have strengthened that process. On top of that, we've also centralized our foster care practice from back then till now to assure that we have consistency and standardization across all 14 offices, so that the process that occurs in Norwich that same process will occur in Torrington without deviation of practice or any variation or subjectivity one may want to inject in the process, that everyone is following through. Because again, this is one where every I have to be dotted, every T have to be crossed 100% of the time. And we can't afford any kind of lapse in that. And so centralizing that, and we also centralized our entire child protection system back then. The service system itself was organized and structured around 6 regions that were kind of independent and autonomous regions. So one region may have operated, based on nuances that they felt were unique to their region, while another region may operate it differently. That no longer exists. All of our area offices are under one centralized set of leadership around our practice to assure, again, standardization and consistency from office to office.
I appreciate that, and I'm not going to take up any more time of this committee at this time. I think I've made my views clear. This is the way I look at it. I'm a dad. I have 2 sons. They're older now, but when my ex-wife and I when they were little, we would go out and you would ask friends and neighbors and relatives who's a good babysitter. I'm just simplifying the analogy. And you would especially if it was your first child, it's a while before you even feel good enough to leave them, unless it's like the grandparent. But you at some point you need some time as a couple. And so just to go to a restaurant for a couple hours, and God forbid you come back and it's some young lady that someone had highly recommended, but all of a sudden you come back and your child, who's just a little more than an infant, has broken bones and brain trauma and all that stuff. I mean, I would never, as a human being, probably recover from that trauma. That what an incredible lack of responsibility. And how did I make a mistake in ever trusting my child to that person? Well, slightly different circumstances, but this little guy was entrusted to the state of Connecticut. And we completely failed in our mission through not following through on these things. And, it's dollars, and dollars are important, but dollars are fungible. And, I want to make sure they're used wisely, because $12 million in this building is a substantial amount of funds for programs, and people are out there. I have towns clamoring for $10,000 for a particular program to serve a lot of children. And so we're in this spot. But the other thing is this, and Senator Winfield knows, I stood up and spoke highly in favor of the renomination of our current DCF commissioner, and I highly commend her. This was back in another era. And luckily, I'm not seeing any of that. And the whole tenor of that department seems to have changed. But you are the ultimate safety net for the state of Connecticut. First of all, DCF has one of the most difficult jobs going, because you're dealing with these dysfunctional families who are just not being responsible for whatever reason. And it's not a judgment call. I am a hopeless sinner. It's Ash Wednesday. I know that people are not perfect. But there's very little wiggle room for DCF, because like you said, once you take your eye off the ball, or the I is not dotted, or the T is not crossed, really horrific things like what happened to Dallas can take place. So in the great circus of life, you are the ultimate safety net at the bottom of the trapeze. And if something goes wrong with the safety net, there's nothing there to catch who's going to fall through, like this poor young man. And so I hope that, and it sounds to me that the history of this, just as far as functioning in the department, that there's tons of lessons learned so that this will not happen again. Will there be other settlements coming before us? Yes, there will, because no one's perfect. We're not perfect. It's a complex society. Things are changing all the time. And is this a large amount of money? Sometimes people look at the state of Connecticut, billions of dollars in our budget and things like that. But, my constituents are struggling with inflation and everything else. And $12 million in taxpayer dollars is a lot of money. And so I appreciate the efforts of the Attorney General's office. My best to our former co-chair, Attorney General Tong. I know you guys worked real hard on this. And like I said, my job is to watch the taxpayer dollars, but it's also to watch the little guys and little girls out there and make sure that we as a state take care of them. Basically all of our constituents, but in particular, those that are frail and in need. And that's our young people, our children. And so I've made my statement. I think that I wish we had more latitude to do something as a committee, but I'm glad there's lessons learned. And I know that you guys did the best you could, and you've answered my questions. Thank you very much, Chairman Staffstrom.
Representative Fishman.
Thank you, Mr. Chairman. Good morning, everyone. You know, I don't often make introductory comments, but I find this matter calling for it. I do agree DCF has a very difficult job. I've been practicing law in excess of 20 years and have dealt with DCF many times. I will tell you that even today, you know, I get a call from a dad who recently got a call from DCF. He's scared. How do I deal with that? Because the perception is that his kids are going to be taken away. And I calm him down and tell him that over the last 10 years, in my experience, things have gotten better. But here, with the light being shined on this, how can I assure him going forward that even if his kids are taken from him on a temporary basis, that additional harm, assuming that there was harm done to give rise to the removal, won't happen. So that's a significant part of what I want to talk about today is where do we go forward? But before we get there, my understanding and review of the documents from the court case is the probate court had to approve the settlement. And my understanding is that within the context of that the fees, the $12 million is to be held by the law firm. And I would expect that they're going to take their fee from that, and then the remainder is going to be held in some form of trust. Is that fair to say?
That's my understanding.
And in the context of administering that trust on behalf of this young man, am I to understand that the law firm will be gaining additional fees for doing that activity as well?
I don't know the answer to that, but I would let you know that members of the law firm are here in the event you want to ask them any direct questions.
Okay, I think I see a few of them back there and they're indicating in the negative that there is no intention to, and that's, I'm glad for that answer. You know, as to the admission of liability, I would expect that when the situation was brought to the attention of the department, which was late in 2016, correct?
2015.
Okay.
Yeah.
So we'll go back even further, that a internal investigation was done at that time, and DCF and the powers that be, perhaps at the AG's office, were knowledgeable as to the gravity of the situation way back then. Is that fair to say?
That's my understanding.
Okay. So one must question why in 2020, many years later, when the action is filed and the allegations are made that these grievous acts have happened, negatively impacting the child, why initially the state takes the position to deny the gravity of the situation.
Well, to answer, for the record, Carolyn Signorelli, Assistant Attorney General, just so in case that needs to be clear. The state started the Claims Commission back in 2017, and the state did look at trying to resolve the case early on because of our knowledge of the gravity of the situation. And in fact, there had been a hearing in front of the legislature, I believe it was the Children's Committee perhaps, in February of 2017, where the state did acknowledge the problems with the case. However, from our office's perspective, you know, we do our best to zealously represent the agencies and make sure that we're dotting all our I's and crossing all our T's, and, you know, just making sure that we fully explore all the facts, all the potential defenses. But we did agree for permission to sue to be granted in this case. So at the Claims Commission, we reached an understanding that we would allow and agree to permission to sue to be granted and waive our sovereign immunity, so that it could be filed in Superior Court so that we could start negotiating a settlement. And part of that process in trying to negotiate a settlement, required us to continue to do our due diligence and to continue to do discovery and flush out all the facts. And, eventually we determined that, there really wasn't a defense to liability and that the best course would be to go to a hearing in damages. But there was a lot of negotiation going back and forth, and the initial process, the demand that was made upon the state was much higher. So it required us to continue to do our due diligence and develop our case in order to be in a better position to negotiate the settlement that we have now. So if we had just, not done any of that, we might have been, facing either a much higher award at trial or a demand that wasn't being negotiated down from the plaintiff's perspective.
No, I understand. And I'm hearing everything that you're saying. My concern is the utilization of the litigation process to try and negotiate down a number. I mean, it's 4 years past the closing of the investigation. The OCA report was issued October 4, 2016. So 4 years later, a lawsuit's brought and the state takes the position that we're going to deny liability because the number's too high. And that's, right? That's generally what you said. And that's troubling, for the family, for the, because even after that, we have disclosures of experts and the state's taking the position officially in the file that we're going to disclose an expert basically challenging liability. So we're moving forward from there. What's the situation with other potential claims here? I mean, this is one case brought by not the biological, is it brought by the biological parent?
Originally, but they were substituted by a guardian of the estate and then by the adoptive parents.
So is the door closed on the biological parent bringing an action also against the state?
That's my understanding.
Okay, is that part of the settlement here?
It is not, but any statute of limitations have passed at this point.
Okay. So then the juvenile court, because there was an OTC here. Originally, DCF comes in, they took the child, placed it in foster care, but we have to adjudicate the issue, right? So it gets to juvenile court. And in that proceeding, someone was appointed on behalf of this child by the juvenile court, correct?
Correct.
And was that a GAL or an AMC? AMC being attorney for minor child.
So the way the statute reads pursuant to the appointment of counsel for children, 46B-129A, all children receive an attorney. However, depending upon the child's capacity, the attorney may determine that they have to act more as a GAL and act in the best interest of the child. In this situation, because Dallas was nonverbal at the beginning of the case and for much of the case, the attorney was likely acting as a guardian ad litem or in the best interest of the child, since the child did not have the capacity to, communicate to the attorney.
Yeah, I mean, I'm trained as a GAL and, as an AMC, there is an aspect of best interest, which brings the GAL aspect into it. But when I review the OCA report, it indicates that in addition to DCF and approximately a dozen individuals from DCF just ignoring protocols, procedures, or not being trained properly, the lawyer also was at fault here. Is that fair to say?
That's my understanding of the OCA's conclusion. Yes.
So why procedurally, when the state is sued, alleging that the agency did wrong and is denying liability, why didn't the state say, lawyer, you screwed up too?
Well, my understanding is that the lawyer is contracted through the public defender's office and is also indemnified by the state under 4-165. In addition, the lawyer has, immunity defenses. So I mean, I did not see that it would make sense to try to bring the lawyer into the litigation.
So not only did DCF do what it did, but also a representative of the public defender's office. Is that?
So a private contract attorney that contracts with the public defender's office to provide this representation.
So because of that contract, they have immunity?
Correct. There was an amendment to 4-165 to include those attorneys.
Are there any other cases that are currently pending that are similar to this?
As in factually a child who was placed with a relative type of situation that was
Actually,
injured?
somebody a child that was in the care of DCF, that now DCF is being sued for not following practice and protocol.
I believe there are other cases like that. Yes.
Approximately how many?
I can't answer that question specifically
Is
because
it possible to get me a list of those cases that remain pending?
yes,
Thank you. And how long would it take to get that list? I'm not asking today. I'm just saying,
Good morning, Representative Fishbein. I'm Lindsley Barbado. I'm the section chief for the group of attorneys who defended this case, of which Carolyn is a part. I could get you such a list within a week. My memory is that there is no case similar factually to this one that we have pending, but there probably are 15 or so cases pending where there were children injured in the care of foster parents, and I will get you that list.
I appreciate that. And, that's of concern because, one tries to say that this case is a one-off and, we had the situation, I think it was in 2018. I was new to the legislature talking about the Juan F case and, the federal oversight being removed over DCF. And I believe there was a bill that was passed that created a level of oversight, and our governor at the time vetoed that. Unfortunately, I didn't get to come back to the House chamber to vote on an override of that veto. And, I'm just really concerned about, the power that DCF has to walk into homes and take kids and potential problems. I know we met a few weeks ago and I had mentioned, body cams for DCF workers. I mean, there's a lot of good DCF workers out there, but what do we do to protect our kids? So I do thank Attorney Passero or Assistant Attorney General Passero for getting me a document yesterday having to do with what has been put in place to try and protect kids going forward in the state of Connecticut, kids and parents. And one of the things that happened here is the waiver process was just ignored, right? A kinship waiver. And basically my understanding is that everyone who is going to take a child into foster care as a result of DCF intervention is supposed to be background checked. They're supposed to, do they have a criminal background? Have they been previously adjudicated neglectful or abusive through the DCF process? And in this case, the foster parents that the child was placed with, Crystal had a criminal conviction that would have disqualified her, as well as she had been previously neglectful or found to be neglectful or abusive of her child. I just wanted to stop. That's all correct, right? I didn't say anything was wrong, right?
You are correct.
Okay, so with a kinship placement, it can be waived. And apparently in this process, that waiver was never sought nor granted. Yet the child was put in the care of these adults, and what happened to the child happened. That's correct, right? I didn't say anything that was incorrect.
That's my understanding, correct?
So at that time, who would sign off on a waiver? Who would have the ability to?
So during that period of time in 2015, the waiver that is being referenced is used to complete the full licensing process for a kin relative. And if there are things within their background that will prevent the full licensure to occur, then that waiver would have, particularly if it's criminal history or child protection history, would have had to come up for a commissioner's approval.
When you say not the commissioner, but a commissioner, when you say
it is the office of the commissioners, depends on an administration. The commissioner themselves may sign it, or they may delegate that responsibility to the deputy commissioner. In this case, today, Commissioner Durantes delegates it to me, and I sign on behalf of Commissioner Durantes those waivers.
okay, so that was the process back in 2015 when this is going on, and and remains unchanged to today. Is that?
That is correct.
Okay. So in the backup that I got yesterday with regard to what we're doing moving forward, it indicated the waiver policy can be found at DCF policy 24-1. I went and got it. And what that says is that it's on page 10 of 15. A waiver of criminal history and pending criminal cases. And it says who the approving authority is. It says commissioner, if precluded by RCSA. RCSA is a regulation. It's 17A 145-152, which I went and got that one too. Well, it's in here anyway. It doesn't say that the commissioner can delegate. It says commissioner, if precluded by RCSA 17A 145-152, which is the criminal history background. Otherwise, CPS program supervisor and FASU program supervisor. So based upon your own internal document titled Foster Care Services, it doesn't say that so that's part of the problem here, quite frankly, is nobody, based upon the OCA report, nobody knew who could do what, who could sign off on what, who could delegate to who. So how do I put that together? You just said that the commissioner can delegate that power to you. Under what authority?
Being her designee.
Okay, but it doesn't say in the DCF policy or her designee. I mean, and regs are approved by the legislature. So, I mean, I guess I defer to one of the attorney generals or something like that. where is the power to lawfully designate from the commissioner to their chosen designee a waiver of a criminal background finding through the process?
Well, I'll take a stab at that question, although I haven't specifically researched it, but under the statutes that provide the commissioner with her authority to do all the things that the legislature has delegated to the Department of Children and Families and the commissioner, I'm pretty certain that most of the statutes that give her the specific authority to do what she does indicate or designate, because it would be, impossible for the commissioner to, personally be involved in every single, decision that has to be made. So the statutes provide that she can delegate things. I'm not certain what that specific regulation says, but I believe that she has the authority under the statute.
Well, I'm gonna tell you, this section on waivers, right? It has a bunch of different waivers, okay? And the only two that say that the commissioner has to sign off on it are criminal history and pending criminal cases and substantiated child protection services history or pending CPS cases. Everything else, every other waiver, child's bedroom, clothing, privacy, in-home daycare, financial condition, food and water, through all the animals, health standards, they all allow for supervisors to sign off. These two specifically just say commissioner. So I'm hoping, I've got fingers and toes crossed that the multiple conundrums that were apparent in 2015 are going to get worked out, because this is not clear. If there's a different authority, these people should know what the hell what they're supposed to do and what they're supposed to follow. But moving forward from there, once again, staying in 24-1, the foster care services overview document. We have the issue of the registry. And I have familiarization. I'm familiar with the registry. So the registry is an internal process by DCF where they adjudicate someone neglectful or abusive, and they have a list that they internally maintain. In my experience, it's difficult to get off the registry after a significant period of time. In the waiver section, it says the placement of a household member on the central registry of abuse or neglect of children is a safety requirement that cannot be waived. Prior to the placement, the regional office must review any such central registry finding and, if appropriate, reverse the decision and remove the person from the central registry. How procedurally does that happen for these waivers?
Do you want to take that one?
Sure. That can happen quite often, and the reviewers are the legal teams in each area office, the staff attorneys in each area office that look at the circumstances that cause that household member to end up on the central registry. Just a caveat to our central registry process, that when it went into effect, people who had a substantiation for abuse and neglect were automatically added to registry without any discrimination because of our IT system. And so a lot of folks who are on central registry aren't there because they are a danger to children. They're there because of a technical glitch in the conversion and the creation of the central registry process over a decade ago. And it just swooped a whole lot of people in on that. And so our staff attorneys were able to look at what happened on a case that created that person to be placed on the registry and can make a determination to reverse the registry placement locally in each area office.
So and I'm sort of getting into a different area here, okay, and I recognize that. But this registry is used against individuals in other areas. And I would hope that if you have people on this registry that did not receive due process because of a computer glitch, that at some point somebody finds the time to review everyone that is on that registry, and whether or not they can be arbitrarily removed from that list, I think would help a lot of people in this state. I'll leave it at that, but I have to say that I'm concerned. I appreciate Attorney General Passaro's cooperation and discussions with regard to this. I'm very concerned moving forward. I'm hoping never to see a case like this again. So that's the best I can say. So thank you, Mr. Chairman.
Representative O'Day.
Thank you very much, Mr. Chairman. And I just want to thank everyone that's there for showing up and answering questions, particularly Mr. Williams. I know you're not in the easiest seat to be in, particularly based on this case, but I do appreciate your sincerity and being forthright and accepting responsibility for this embarrassment, as you put it, on behalf of the DCF. You know, in looking through the memorandum and response, you know, I do appreciate the detailed nature of that. And Mr. Williams, do you agree that, do you believe that the best thing to happen since this case was a centralization of all of the foster care division from 14 to 1?
Yes, I do. Not just foster care, but overall child protection services. The fact that we have 14 offices that operate from, you know, the investigations to ongoing services to foster care requires us to assure that every office is providing consistent and standardized approaches and responses to all of the citizens of Connecticut, so that they're not getting treated differently based on where they live.
Were there any recommended changes that weren't made as a result of this case, Mr. Williams?
I can't recall any changes that came, any recommendation for change that came as a result of this case that was not implemented. Again, it was 2015, 2016 when that occurred. Administration changed over in 2019. And during that period prior to change of administration, I really can't think of a recommendation that surfaced that was not followed.
Mr. Williams, not to put you on the spot as I have already, but I have to tell you the most troubling part of this report to me was the paragraphs on the staff, on the staff discipline and human resource investigations, the breakdown in communication among leadership and the labor relations. Can you just go in? Are you familiar with this memo? I didn't see any signatures on it, but are you familiar with this memo, Mr. Williams?
If you're referencing a memo that is dated 2/21/23, submitted to you.
Oh yeah, I'm sorry. Yes, I see. Yeah, that one. Yes,
yes.
I saw.
Mhm.
And I see Mr. Russo, who I know. The paragraph about the staff discipline and human resources investigations is very troublesome to me. What has been done to make sure the breakdown of communication and leadership, besides the centralization, won't happen again?
When this incident occurred and it was clear that there were policy violation and some just practice, significant practice deviations and egregious actions on behalf of the staff. The review of the case that immediately occurred at this time, it was the commissioner, the legal director, the human resource director, and the leadership of the office, and others. When it was identified that that was the case, the procedure back then and now, that immediately upon a review of an incident such as this, the commissioner, along with the, at that time, director of human resources, would meet to determine the level of human resource investigation or interrogation needed to be applied to the situation. That is still the same process that's in place, and it has been consistent for quite some time. It appeared as though in this situation that the decision was made to conduct a human resource investigation on this situation. Unfortunately, as listed in the document, our HR department assumed that it had started and initiated, and only to find out that it had not.
Was every employee that cut corners disciplined to your knowledge?
Those that cut corners, yes.
And you're comfortable that all those that were responsible have been properly disciplined and including termination to the extent needed?
I am comfortable with the process that occurred to address the employees who handled this case. Sadly, and just tragically to say, a good number of them were leaders in the agency, had great reputations, and were known for good child welfare work. And this does not and did not represent the work that they have historically done over their careers. And unfortunately, they had to pay the price.
And to Senator Kissel's point, I agree. We're not looking for retribution, but we are looking for accountability. And it sounds like, Mr. Williams, you believe there was accountability for those responsible based on what I'm hearing. Is that fair to say?
That is fair, yes.
Maybe a question for the AGs, the assistant AGs. Look, as someone who has handled cases on behalf of minors and defended agencies before, I am familiar with the process. Who was the expert, the neuropsych expert doing the TBI investigation or analysis? Do you have that information? I don't know if that's Attorney Singularity or
Attorney Signorelli.
Signorelli, I'm sorry.
It's okay. So the state's expert was a Dr. Nelson Dorter, a neuropsychologist who specialized with children.
And how about the state's vocational planner?
Her name was Stephanie Noel.
And I'm sorry, I'm not there. What's the name of the plaintiff's firm?
The law offices of Robert Reardon.
And in listening to everything, I would agree the strategy of admitting liability was the right one, based on the limited facts that I have. But hearing you and looking at this memorandum, does Mr. Williams, does the department rely on algorithms to determine which children are at risk, or is it strictly based on visits and reports?
No, we don't use algorithms. However, we do use a standard safety decision-making tool and instrument for an assessment to determine whether or not, based on that assessment and the facts that may surface during the assessment process, a child is safe or unsafe or conditionally safe, or the three kind of outcomes that can occur by applying an instrument that we use, but it's not an algorithm.
Okay. And you're comfortable that the policies and procedures in place now, since this incident, will do more to prevent this from happening? As Senator Kissel said, we can't prevent it in perpetuity, but we can do as much as we can to try and eliminate the possibility. And you feel like what's been done since this case is as much as you can do to make sure it doesn't happen again. Is that fair to say?
That is fair to say. I can unequivocally say that the primary mission and result we strive to achieve at the Department of Children and Families is to make sure, first and foremost, children are always safe, whether they're home with their biological families or in the care of the Department of Children and Families and foster care with foster families or in group care, no matter where. Safety and child safety is our primary mission.
And I do acknowledge, well, let me ask you this. My understanding is that do you find there's a shortage of foster parents available for placements?
Relatively speaking, I mean, there's always a need, but Connecticut is much better off than many other states when it comes to caregivers who come forth and, volunteer to be foster parents. We have three kind of types of foster parents in Connecticut. One is those who we call core foster homes, those are individuals who go through the training, go through all the prepping processes and all that before they take a child. And those children they take are usually strangers to them. Those are the core homes. Then we have a kinship foster care system, which are those individuals who come forth on a moment's notice whenever, again, as I mentioned earlier this morning, children are unsafe in a home and want to keep them with people they know. Those become kinship foster placements. And then we have a therapeutic foster care system, which is for kids with high levels of acuity based on their presentation. And those are specially trained individuals who can care for kids when they're placed with them with those high level of mental health needs. Those foster parents get a lot more preparation and training to meet the needs of those kids. So it's those three levels, and we do well. The third level, however, is one where we're really struggling, can improve our recruitment for people who want to do that level of foster care service.
Have you, as an agency, have you found that the reporting has increased, decreased, or about stayed the same over the last 5 years, in particular since the pandemic?
So we have seen record number of child abuse and neglect reports made to our care line, starting like in 2017, around 2018, due to the mandated reporting laws that's on the books, that has caused many of our mandated reporters to escalate the number of reports that have come to DCF's attention. Those reports dropped off quite significantly during the pandemic in 2020, 21, and now at the end of 2022, they have reached record number again.
Can you get us, and I apologize if it's somewhere easily attainable, but the number of reports just in the last 5 years, I looked for it, I couldn't find it handily. If someone could point that to me or get that to us, I would appreciate it. How would you say, Mr. Williams, the way you find out about successes and failures, and is it mostly through internally, or is there some other way that you have some result-based accountability? If that question makes sense.
It does. I mean, me personally, because I am not directly involved in the day-to-day management of the casework, I rely on the structure that's in place, our centralized structure, which includes in each area office a director who have managers that manage the day-to-day work, and they all of their work and the data from their work feeds into performance dashboards that we have to let us know at any given time how effective we are in doing our work, from like how many investigations are completed within the 45-day time frame, how many cases that are open have received a supervisory review within a 30-day period. So I can go in at any moment along with other folks in our quality assurance department and other leadership and look at all of our performance data to tell us how the performance is occurring across all 14 offices. And we can pinpoint with that data and drill down to determine if there's some challenges, which office, which unit, and sometimes even which social workers are being challenged to make their face-to-face visits or get their case plans in on time and things like that.
Excellent. And I don't know if it was one of the attorneys general who had said that maybe one of the lawyers for the plaintiff would be available to answer a question or not. Obviously,
Representative O'Day, that's actually not kind of the process. The process here is report by the Attorney General's office.
that's fine. I heard it being offered. I'm not going to press it. I was going to actually have the good senator had asked if, on the attorney's fees question, we already have a statute in place that there's a statute that has the attorney's fees structured such that it's reduced as the award gets higher. So we already have that in place. I don't know if that waiver there was a waiver in this case or not. But generally attorney's fees get lower as the award gets higher, to the point where above $1 million, it's 10%. So obviously, Mr. Chair, I'm not trying to go into an area you're on beyond the AG's office. Is the AG aware of whether or not a waiver was set forth, or the statutory fees limited pursuant to our current statutes, if you know?
It's my understanding that a waiver was agreed to.
Okay, so in this case, there'd be a straight third across the board. All right. And for those that, does anyone know who executed that waiver on behalf of the minor? Would that have been the probate court or a guardian that was put in place?
So the minor child's father was the guardian of the estate. So it would be my understanding that, and he's also, the adoptive parent. So they entered into the agreement.
Okay. All right. Well, I appreciate the Attorney General's office's handling of this matter. I appreciate Mr. Williams, you coming forward and answering our questions. And I am hopeful that we don't see a case like this ever again. And I appreciate everyone's time for answering my questions. Thank you, Mr. Chairman.
You, Representative Osborne.
Thank you, Mr. Chair. And by way of reintroduction, Attorney Signorelli, I may be new to the Judiciary Committee, but I am not new to child protection law. And in fact, Attorney Signorelli trained me way back in the day when she headed up the CCPA. I had been in the corporate world, joined Lawyers for Children America as a pro bono GAL, and then entered the world of child protection and served in that capacity for 5 years on the New Britain juvenile panel. So I do have a lot of familiarity with the subject matter here before us today. And of course, this is one of the most tragic outcomes that you can hope to see or worry to see in these types of cases. And I do remember when the switch was made to increasing foster placement in relative care. And I remember the waivers that were happening at that time around 2013, 2014. And I remember distinctly the colloquy among my colleagues worrying about the the lack of adherence to the same standards in kinship foster care that we saw in the core foster placements. And I do remember the colloquy among our colleagues saying, well, you know, the pendulum swings one way and then there's going to be a tragedy. There's going to be a horrible tragedy and the pendulum will swing back again. I'm not familiar with the current state of this. I haven't practiced in juvenile court since 2014, I believe was my last case, perhaps 2015. And I'm wondering what steps have been taken to make for further oversight in the kinship foster system. I hope that we're not seeing the same kinds of waivers that led to, or lack of oversight that led to this situation. But kinship care is not always the best care. And I'm wondering if you could speak, perhaps, Mr. Williams, you could speak to what oversight has returned, hopefully, to kinship foster care.
Sure, and really thank you for the question, because I think it's important as it relates to this case that we say this is not kinship foster care. This is what we say in our industry, like dump and run. This does not represent anywhere close to the standards of what kinship or relative foster care is in Connecticut compared to other states. When a child is in the custody of the Department of Children and Families, and we place them, every placement has to be a license or approvable placement. Compared to some states, their kinship placement system isn't licensed and there isn't an approval process, and it's done outside of the foster care system. Ours is done within the foster care system.
Right. I'm familiar with that, but clearly in this situation, the same standards were not applied to evaluating this particular kinship placement. So what steps have been taken to make sure that the waivers that were apparently granted in this case are looked at more carefully when we are evaluating relative foster placement? I guess let's call it that.
Yes, absolutely. And again, the very first step taken is strengthening what is called the emergency home assessment process, which is the beginning stage of kinship placement, that before a child is placed with a relative or a kin, there has to be an emergency home assessment, which is a physical observation, in-person review or visit to that location to review things like bedrooms and smoke alarms and the physical plant that the child will be living in, looking at things like, is there enough food in the refrigerator? You know, basic things that sometimes people can take for granted have to be checked off on. There's a checklist of all of the items and standards around an emergency home assessment that must be completed before a child is placed there. In addition, if that relative that have come forth to be the caretaker for that child has a hit on their background, such as a criminal or a substantiated investigation for abuse and neglect, we don't place children in homes where there's an active substantiation of abuse and neglect, or if a child or if a caregiver is on a registry, unless those can get resolved.
Is that a change from what was happening back in 2015? Because I recall there being waivers for families that had substantiations in the past. Is that practice stopped?
No, I'm saying that placement cannot occur unless the commissioner approves it. And normally that will not be an approvable request by a commissioner unless there is a way to remedy and to address whatever that substantiated finding is on the caregiver.
And so back to Attorney Fishbein, or Representative Fishbein's question, Attorney Fishbein is accurate as well. Back to that question, that has to be a specific waiver by the commissioner, not by the social workers making the evaluation of that possible relative placement?
That's correct.
Okay. In addition, this is probably a better question for Attorney Signorelli. I recall that back when I was doing juvenile work, as a contract attorney, first under your auspices of your office and then under the public defender's office, this is really hard work. It's extremely hard work for DCF and it's extremely hard work for the contracted public defender attorneys. And the contracted public defender attorneys do not enjoy any of the benefits or compensation that are enjoyed either by the actual employed public defenders or by their opposing counsel at the Attorney General's office. I think the compensation at the time was something like $45 an hour for only very discrete tasks. And not all the tasks that you had to do. And you would oftentimes be traveling all across the state, going to visit your child placements. And there's just no way that that level of, I'm going to say, deficient compensation cannot affect the quality of work. There's only so long an attorney can practice in that area for that type of compensation. There are only so many cases one can take in child protection, which really reduces the core competency of people who are not practicing exclusively in that area. And I'm wondering if any changes have been made to that system, because the children who we represent and the attorney, the parents who are receiving representation through the public defender's office deserve adequate, doesn't have to be the very best, but they deserve adequate representation. And I'm wondering if any changes have been made to that system, because it is simply not possible to have the same type of representation against the Attorney General's office under the compensation structure that was previously used. And do you have any information on that?
Well, I can't speak to everything that the Public Defender's Office has done since 2011, but prior to that, the compensation had been significantly increased for the attorneys. My understanding is that it's back to a per case fee. And then if there are certain discrete tasks or a case goes to trial, then there is an hourly rate in addition to the per case fee.
And is it more than that $45 an hour that you can't hire a paralegal for anymore?
I believe it might be $55, but you can't quote me on that.
Thank you. And thank you, Mr. Chair.
Representative Conley. Representative Conley, did you have a question? If not, let me check. Are there other members of the committee that have questions? Representative Labriola.
Thank you, Mr. Chairman. I actually was listening in my car on the way up here this morning, and I thought I heard some questioning from Senator Kissel to, I think it was Attorney Mesco, about whether the Attorney General's office had any discretion or any ability to negotiate attorney's fees. And if I heard correctly, the answer was that he really didn't have, that your office really didn't have any discretion in determining what the attorney's fees would be. First of all, did I hear that correctly?
That's my understanding, yes.
Thank you. And I'm just catching just now a question from Representative O'Day regarding whether a 1/3 attorney's fees in this matter is included in the settlement. And I thought I heard you say that there was some waiver that was, did I hear that correctly? Or do I understand this correctly, that the Attorney General's office had the discretion to allow a 1/3 attorney's fee?
So that's statutory. So the statute that provides for contingency attorney fees, it's my understanding that the statute provides that over a certain amount, the percentage for the attorneys gets lower. However, the statute also provides for provision where the client and the attorney can reach an agreement for a contracted fee of up to 1/3 of the settlement.
So it was really a decision made between the client and the attorney?
That's correct.
And there wasn't any ability of the state to not allow that
That's
1/3?
That's correct. We're not in a position to interfere with the relationship between the plaintiff and their attorney.
Thank you.
Ma'am, do you have that statutory citation handy?
I do not have it off the top of my head, but I'm sure we can get it. 52-251C,
52.
251C.
Thank you. Further questions or comments from the committee? Further questions or comments from the committee? Representative Fishman.
Thank you, Mr. Chairman. I just wanted waivers once again, just want to go back to the waivers. So when somebody's going to be placed in foster care, child's going to be placed in foster care, and an individual has a criminal conviction on their record, who determines, in order for that placement to happen, a waiver would have to be signed, right? Is that fair to say?
Yes.
And who determines whether or not a waiver is necessary today?
Whether it's necessary,
Yes.
the area offices, as they do the background checks of those who come forward. And if they find in the background that there's a child protection history or a criminal history of a person's come forth, they then make the determination, do they want to send this candidate up for a waiver approval or move on to the next candidate?
So so someone at DCF pulls the criminal history, reviews that, and makes a determination whether or not that conviction and or convictions disqualify that individual from foster care placement. Is that fair to say?
That is correct.
And is that a supervisor? Or is that what?
Well,
level?
I think it could be the social worker on the case, the supervisor on the case, or the manager. I mean, the fact is that when a candidate comes forth, we have the mechanisms to immediately do the criminal background check to see if there is a local estate police history on a person and know exactly what that is based on what shows. If it shows a significant, or disqualifying criminal history, they then know right at that moment, there's no need to even pursue this person.
So if that particular individual has the ability to say a waiver is necessary, they also have the ability to say a waiver is not necessary. That's fair to say?
Well, they will know that they can't put the child there unless there's a waiver, and then they would have to make the determination later on, if that's a placement that they really think the child should be, to send that up the chain for an approval of that, which they probably know won't get approved. But the point is, they have that information at their fingertips immediately, and it's disqualifying criminal history that they cannot just say, oh, here's the history, I'm going to make the placement anyway.
Okay, so I still understand what I said was wrong. I assume it was not, that a social worker who reviews a criminal history has the ability to say a waiver is not necessary. Fair to say, right? So what do they look at to determine, in conjunction with the criminal history, a disqualifying conviction? Where's that list?
It's listed in the regulations. I don't know them.
That's right.
Yeah.
17A 145 152.
Well,
Can you give me any statutory listing or any crime that is specifically listed in the regulation disqualifying any individual?
sure.
You can't, because there are none. There is not one. This list is wholly subjective. So by way of it says a person has been convicted of impairing the morals of a minor or other similar offenses against a minor. That's subjective. Person who's been convicted of possession, use, sale of controlled substances within the last 5 years. That's pretty specific. Illegal use of a firearm
Mhm.
or other similar offenses.
Mhm.
So for instance, 5380A is the manufacturer of bombs. So he's been convicted of manufacture of bomb. Is it similar enough to a firearm conviction so as to disqualify this individual?
It could. I mean,
It could be, yes.
Yeah.
And if we asked everyone in this room their opinion. I'm gonna almost guarantee you that at least 20% are gonna say, no, it's not a gun, it's a bomb. So how? This is present law today. This is the determination of waivers. There is not one statutory reference in the regulation. I'll give you a copy.
Please,
Yeah,
I'm sure there is, but
I just, I sit on regs review. I look forward to Attorney General's office perhaps suggesting a list. I think it would be helpful going forward. Because what we have here is still subjectivity, and I'm looking to protect kids. So certainly somebody who makes a determination that manufacturing bonds is not a disqualifying conviction and something bad happens, I don't want to be here again. So thank you, Mr. Chairman.
Representative Conley.
Thank you, Mr. Chair. And again, I appreciate the Zoom ability because I had a tire problem this morning and haven't been able to make it yet to the Capitol. But I did have a couple questions about the settlement health insurance. Was the minor on Husky when his medical bills have been paid?
Yes.
And does the settlement take into account any Husky lien?
I don't believe there is a lien. There's not a lien for expenses paid for children on Husky.
So there generally is a lien for accident-related medical expenses. Is there a waiver of that lien as part of the file?
No, it's my understanding that currently under statute, we don't do liens for benefits for children who are in the department's care.
So generally for personal injury settlements, for personal injuries, there is a lien for accident-related expenses paid for on behalf of the person receiving the funds. So I hope that does get looked into before paperwork is finalized to make sure that the final releases illustrate the settlement correctly. In the releases, is this a one-time settlement or is it a structured settlement?
One time.
Does the release have a special needs trust or is that left on behalf of the minor child's attorney?
My understanding that that's being handled in the probate court.
Okay. And a release of this or settlement of this account or amount has to go through the probate court
That's correct.
to make sure that the minor child's needs are and their finances are being held so that their needs are appropriately addressed over the course of their lifetime for a minor or a disabled minor, such as this unfortunate gentleman's situation.
Yes.
Okay. Thank you. If there's an update as to lien or documents, please update me.
Further questions or comments from the committee? Further questions or comments? If not, I would just like to conclude with certainly associating myself with I think the remarks and I think the sentiment of most of us on this committee that this truly is a horrific incident and one we hope we are never dealing with again. I just want to ask Attorney Meskel, just for the record, it is, I assume, the Attorney General's office's position that this settlement is the most fair and just outcome that can be achieved, and are accepting it is in the best interest of the state of Connecticut?
Thank you. Yes, I agree with that and appreciate the opportunity to be here today. And we recommend approval of this as the best, fairest settlement in this case.
And I assume the funding for this comes out of the AG settlement fund?
I believe that's correct. The litigation fund, I'll defer to anybody else if I'm wrong.
Attorney Passero.
It would come out of the adjudicated claims fund, which we understand pulls from the unobligated funds in the general fund. So no appropriation is required.
All right. With that, we will move on to item number 4 on our agenda, which is and these are Senate resolutions and House resolutions. So the first one will be a Senate resolution. I will entertain from a senator a motion to approve Senate Resolution number 16, a resolution approving the stipulated agreement in Dallas Church by his next friend and father, Jerry Barros versus the state of Connecticut. And I have a motion from Senator Winfield, a second from Senator Kissel. Madam Administrator, please call the roll.
Roll call vote on Senate Resolution 16, Winfield. Flexer, Kissel. Gaston. Harding. Lesser. Mar.
Senator Mar votes yes.
Miller. And Sampson.
We will hold the votes open until 2 o'clock. Next, we'll move on to item number 5 on our agenda. I will entertain a motion from a House member to approve House Resolution number 18, a resolution approving the stipulated agreement in Dallas Church versus by his next friend and father, Jerry Barros versus the state of Connecticut.
So moved.
In a second. I have a motion from Vice Chairman and a second from Representative Osborne. Is there discussion? Is there discussion? Seeing none, Madam Administrator, please call the roll.
Roll call vote on House Resolution 18, Staffstrom. Quinn. Fishbein. Blumenthal. Callahan. Conley.
Rep. Conley votes yes.
Curry. Delaney. Dillon. Doucette. Dubitsky.
Dubitsky is yes.
Elliott. Gilchrist. Godfrey. Hall.
Yes.
Hayes.
Yes.
Howard.
Yeah.
Johnson.
Representative Johnson votes yes.
Khan. Labriola.
Yes.
O'Day.
Representative O'Day votes yes.
Osborne. Pavlock D'Amato. Porter. Sims. Veach.
Representative Veach votes yes.
Walker. Wilson.
Representative Wilson votes yes.
Representative Delaney.
Hello, Madam Administrator. Representative Delaney votes in the affirmative.
Thank you.
Thank you, everyone. That concludes our agenda for the day. We will have a public hearing on Monday, the 27th, on substantive bills. We will see you all then, and we stand in recess until 2 o'clock.
Hello. Representative Delaney, you're all set.
Thank you, Madam Administrator. Sorry, thank you, Madam Administrator.
You're welcome. Take care. Okay.
You too.
You too. Thanks. And Senator Gaston for Senate
Hello.
Resolution 15, how do you vote?
Senator Gaston votes in the affirmative.
Okay, excellent. Thank you so much.
Have a great one.
You too. And Representative Doucette, how do you vote?
Hi, Christian.
Hi, Representative Doucette.
Hi, how are you?
Good, and yourself? How'd you like to vote today?
Good. Rep. Doucette votes yes.
Awesome. Thank you so much. Have a good one.
Thanks.
Representative, can you hear me okay?
Hi, how are you?
Excellent. Good, and yourself?
I am.
How do you vote on House Resolution 18?
Representative Curry votes yes.
Excellent. Thank you so much.
Thanks, and have an easy day.
You too. Hi,
Hello.
Representative. How are you?
How's it going?
Good, good. How would you like to vote today?
Yes, please.
All right, you're all set. Thank you.
All right, thank you.
Take care.
Good afternoon.
Hi, Senator. How are you?
Hi, Kristen. How are you?
Not too bad. So it's your Senate Resolution 16 to approve it. How do you vote?
I vote yes.
Okay, that's all I've got for you. Thank you so much.
Thank you.
Have a good one.
You too.
Hi, Representative. Sorry about that. Oh, I can't hear you. You're muted.
Sorry, I've been in environment screenings for about 3.5 hours.
Oof. Catch your breath. Oh my gosh. All right, I won't keep you. So for House Resolution 18, how do you vote?
Yes,
Okay, that's all I need. Thank you so much.
that was
Have
the
a
only
nice-
vote.
Yeah, that's it.
All right. Thanks so much for your help.
You got it. Take care.
Bye-bye.